Y'all got me now? Okay. All right, guys. So this morning, we're going to be getting into some SCOTUS decisions. We have a case right after. There's just Pung v. Isabella, which deals with the takings clause in regard to seized property as well as Eighth Amendment excessive fines. So that should be interesting. But right now, we're waiting on some SCOTUS opinions. I'm not suspecting that there are going to be any big drops, but you never know. Ones we could see, I'm potentially looking at Villarreal v. Texas, which is the first case we actually watched this season, which dealt with the Sixth Amendment right to an attorney when you go to recess. So essentially, a guy was accused of the schmurders, and then they went on a break and they said, well, you can't talk to your lawyer about your testimony. And they said, no, that violates my Sixth Amendment right to counsel. So yeah, we have that one. Chile v. Salazar is the one in regard to the therapist's First Amendment rights being challenged by Colorado law in regard to treating people whose gender identity doesn't align. We also have Louisiana versus Calais. So Chile and Calais both feel like those are going to be June decisions. Now, I could be wrong. Would not be the first time. However, that's generally the way that goes. Couple other ones we could see. We did watch the Rico, Rutherford, and Fernandez. We could see those coming out. Also, we watched Landor, which is now Rico, Rutherford, and Fernandez all revolved around, I believe it was the First Step Act in regard to early release and other things like that. And then well, we already got the tariffs. Sorry, what am I talking about? Landor v. Louisiana Department of Corrections. That was the one where there was a 1983 claim because he was exercising his religious liberty and they cut his hair. We've got the immigration case in December. I mean, it's potential we could see a lot of these, but I'm thinking maybe we'll see Villarreal today, or maybe we'll just get a big nothing burger, but we're still got a case that we're going to get into. So just be patient for a minute and we shall go from there. Oh, looks like we're going to be getting opinions here in just a second. I will start refreshing at 9 o'clock like it is going out of style. And if you have any questions, please put them in the chat. I am absolutely happy to answer them if I am able to. But I'm working on it, guys. Let's see. It's almost 9. We'll see what we get. I never know what decisions they're going to drop. If you want to follow this yourself, you can always go to the Supreme Court website, find opinions of the court, and then at 9 o'clock, you just start refreshing like you have everything to give to it. So I'm refreshing right now. I don't know if you can see it, but eventually the opinion will drop in here. Sometimes the justices get incredibly long-winded when they're reading out opinions. And then right after this, we are going to go into Pung v. Isabella, which is also actually quite an interesting case. Let's see what we got. Let me see if SCOTUS log is reporting on a box count. Set a light box today. Let's see. So this may be something we didn't even cover. And that's okay too, because we still have a case after this that we're waiting on. My apologies, guys. Oh, my decision dropped. And this is actually, interestingly enough, okay, so this is written by Ketanji Brown Jackson. This is the case we covered in regard to the Sixth Amendment right to an attorney. Jackson wrote the opinion of the court, and this is not the last opinion of the day. Let's see what we got. All right. Let's see. David Villarreal's murder trial culminated with his own testimony. That testimony was interrupted by a 24-hour overnight recess, during which the trial judge instructed Villarreal's attorneys not to manage his testimony. The judge clarified, however, that Villarreal was not prohibited from talking to his attorney and recognized Villarreal's constitutional right to confer about certain topics, such as possible sentencing issues. Villarreal resumed his testimony 24 hours later and was subsequently convicted of murder. On appeal, the Texas Criminal Court of Appeals concluded that the order was a permissible exercise of the trial court's discretion. Held a qualified conferral order that prohibits only discussion of the defendant's testimony for its own sake during a mid-testimony overnight recess is permissibly balances the defendant's Sixth Amendment right to counsel against the burden of offering altered trial testimony and does not violate the Constitution. So what does that say? If they're just saying you can't confer about your testimony that you were giving, but you can talk to them about anything else, they're good. So I still think it flirts the line, but this is obviously the opinion of the court. It's not my business to challenge it. They're reading it at a much better level than I can. However, that was the decision I wanted, and that was the one we got today. Let's see what else we got. I'm going to keep refreshing. So that was interesting. That was exciting. I was excited to get that decision. I'm wondering what the other one we're going to get today is. Let's see if I can tell me any more. Yeah, the Sixth Amendment guarantees a fundamental criminal defendant's right to counsel. When a defendant takes the witness stand, however, he assumes the position of a witness with its attendant criticisms and burdens. These influences include the inability to receive advice from counsel aimed at influencing the testimony in light of the testimony already given. All right, well, that's interesting. Let's see, have we got anything else? Sorry, they read these decisions from the bench. Good morning, everybody. I am so glad you're here, and I'm so sorry because it's hard for me to read the chat and balance, but I absolutely love and appreciate all of you. The decision we got already was Villarreal v. Texas. It looks like we're waiting on another one. They said it was a light box day, so I don't know what other one we're going to receive, but I'm assuming it's not going to be very wordy. But Villarreal v. Texas looked at a gentleman in Texas who was convicted of murder. They went into a brief recess, or an overnight recess, sorry, not brief, an overnight recess, and the judge specifically instructed that they cannot talk to him about his testimony with his attorney, but he can talk to him about anything else. And yeah, so the Supreme Court said it was specific and tailored instructions, basically, and it did not violate the Constitution. I still have mixed feelings about that, but again, I can see where the court is coming from because, yeah, you're not assuming the same position you were in. Sorry, guys, I am still refreshing. Let's see what else we get. They read these from the bench, so it's a little rough. Sometimes, let's see. Let me see if they said the other one we got. Not a very puffy opinion. Majority is only 14 pages. What else? It's not the only opinion. It's by Justice Jackson. Okay. Let's see what else we got. I swear to God, Amy Howe, with Scotus blog, just is the absolute shit. She will run in and out of that courtroom to tell you exactly what decisions we're getting. Oh, Geo Group versus Medical. What was this one? Oh, private detention facility. Let's see. Geo Group operates a private detention facility in Aurora, Colorado under contract with U.S. Immigration and Customs Enforcement. Respondent Alejandro Menical, a former detainee at the Aurora facility, initiated this class action alleging Geo's work policies for detainees violates a federal bar on forced labor and Colorado's prohibition on unjust enrichment. Geo responded that the suit must be dismissed under Yearsley v. Ross, which held that the federal contractor cannot be held liable for conduct that the government has lawfully authorized and directed the contractor to perform. Geo argued that ICE has the authority, has authorized, and directed it to carry out the challenged labor policies, but the district court did not read Geo's contract with the government to instruct Geo to adopt these policies. The district court thus concluded that Yearsley Doctrine did not relieve Geo of legal responsibility and that a trial would be necessary. Geo immediately filed for appeal, which the Court of Appeals for the 10th Circuit dismissed for lack of jurisdiction, holding that an order denying Yearsley protection does not qualify for an interlocutory review. Held because Yearsley provides federal contractors a potential merits defense rather than immunity from a suit, a pretrial order denying Yearsley protection is not immediately available. Hold on. Let me let them flesh out this decision because these are more nuanced decisions that I want to read sort of ending here. For those reasons, we hold that the Court of Appeals lacked jurisdiction over Geo's appeal. If eventually found liable, Geo may, of course, appeal to the district court's rejection of the asserted Yearsley defense, but Geo must wait until then. So basically they said, go ahead with your lawsuit. That is all I'm hearing. And hi, thank you everybody for coming in. We're about to get into a case after this. But I wanted to go through those opinions with y'all real quick. Let me see if this has started yet. Nope. All right. So yeah, they said, I got you, boo. Let's do that lawsuit. Let me shrink this a little bit. And sorry, I'm the absolute worst at running TikTok Studio. I am trying to get used to it, my guys, but like I'm terrible at it. I just want you all to know. I think it's this one. Yep, Pung v. Isabella County. And that's the one we're waiting on to start. Hopefully it will start soon. Yeah, the answer is no, because that 1940 case provides defense to liability, not immunity from a lawsuit. An order denying its protection can be effectively reviewed after a final judgment. Yeah, so I love this. We got some good opinions today. Oh, thank you so much, Noah. I really appreciate each and every one of y'all. Y'all are super amazing, and I absolutely love that y'all are here. I'm terrible at TikTok Studio, but I'm working on it, guys. Oh, okay, we're live now, so this should start soon. Let me see if I can change this to make it easier for y'all to read. I realized this background was going to be like this. All right, give me 1 sec. There we go. You're doing Pung v. Isabella County, takings clause in association to seize property and 8th Amendment excessive fines. Yeah, 1 box, 2 decisions. One said no, you can sue that private jail. And the other said, hey, as long as the judge is giving you specific and tailored orders to avoid tampering with your testimony, they can tell you not to talk to your attorney. So those are the ones we got today. We're waiting on this bad boy to start, so we'll see where we're at. Let's see. It says it's playing, so it should be starting soon. Hello to everybody coming in. Y'all are all so amazing. I love each and every one of y'all. Y'all are great. If you can just tap the screen, it helps me a lot. Aside from that, y'all are all ballers. Love y'all to death. Let's see. If they could get this moving, it would be great. Making sure my volume and everything is good. Oh my gosh. Come on, guys. Sorry, y'all. I know it's a pain in the butt. I'm sorry. I know we have to wait on them. They're slow as shit. However, how did everybody feel about the tariff decision? I was, for one, thrilled. Did everybody see the judges at fucking SOTU last night? Like, I feel like maybe there's a reckoning for them in allowing Trump to run so unchecked with immunity. Do you feel like every day they're just sitting with their head in their hands like, oh my God, why in the hell did I fucking do this? Because I personally do. Honestly though, low-key, I know this has nothing to do with SCOTUS. My absolute favorite part of it though, my favorite part was fucking Marco Rubio. He was so fucking sad. I want to see if I could show y'all this because it is the most hilarious shit I've ever seen. Hold on. It's probably going to be backwards because it's in my phone, but...
Thank the Monday report to Secretary of State.
We will hear argument this morning in case 2595, Pung versus Isabella County.
Can everybody hear? Let me know.
Mr. Chief Justice, and may it please the court, the Fifth Amendment requires just compensation be measured by the value of what's taken. The Sixth Circuit's categorical rule reducing just compensation to surplus auction proceeds in all instances was wrong. This court has repeatedly confirmed that when the government takes property, the constitutional calculus begins with its fair market value. That is measured from the time of the take. The error here is clear. The Pung home was worth $194,400. The tax debt was roughly $2,200. Just compensation meant returning remaining equity. The lower courts erred when holding that the later auction price of just $76,000 less the debt was categorically the only just compensation owed. But this court said it directly in Jacobs. An owner is owed just compensation, not inadequate compensation. Following Tyler, there are no windfalls to the government. This case now asks the court to confirm the other half, that the Constitution likewise forbids confiscatory losses when being imposed upon a former owner. Federal courts should consider all relevant market evidence of market value and determine whether just compensation has in fact been paid. In addition to the Fifth Amendment, the Eighth Amendment's excessive fines clause provides a backstop as well. Taking a six-figure home to punish over a small four-figure tax constitutes a fine and was sufficiently alleged to be grossly disproportionate to get past the initial pleading stage. The judgment below should be reversed, and I welcome the court's questions.
What do you do with the fact that the English and American legal traditions seem to permit these sorts of foreclosures?
Thomas?
So the fact that our history allows for these types of foreclosures is only one half of the equation. The other half of the equation historically is that protections have been built in. For example, of one of many is, for example, is personality has to be taken before the real property, for example. This process that Isabella County undertook lacked that second half of that historical tradition. Yes, surplus is the ultimate outcome if, in fact, the auction resulted in a fair market value. But when it doesn't result in a fair market value, historically, courts have been allowed to challenge inequity, to set aside the foreclosure itself, or to otherwise award damages or compensation in those particular circumstances.
I'm sorry, where in your briefs did you show, where in your merits brief did you point to that history? I know that there have been cases that talk about the fairness of an auction and that certain rules were set up to ensure fairness, that it had to be an open bidding system, et cetera. When those were set aside, there's a measure of compensation that's different than the proceeds. But I think what Justice Thomas is saying, there is a long, long history of tax foreclosures, of bankruptcy foreclosures. We've even had a case on that, where the issue is whether the proceeds from that foreclosure have to be fair market value. And we've said no.
So respectfully, that the court, the last word on this has been BFP, which was done specifically in a bankruptcy context of reasonably equivalent value.
No, I'd ask you a different question. Show me cases that don't involve the unfairness of an auction.
This is Sotomayor, by the way.
The
Sorry.
courts have given damages greater than the auction price.
We would point this court. We would point you to Griffin and Ballantyne on this matter that has suggested that when a
Suggested. Give me a holding from a court in our 250-year history where we have said that the measure of damages on a tax foreclosure is fair market value, not the auction price.
there has not been that specific holding in this court's history, but there has been the history of like parallel circumstance foreclosures, of mortgage foreclosures, and other circumstances where the typical market allows.
Justice Scalia said the auction price, you couldn't make it the fair market value because this is not a fair market value sale. An auction is a different forced sale, and so it will yield a different measure.
We would point this court to Virginia Electric that says that any depreciation in the value of the process itself has to be burdened to the government, and it is their responsibility to suffer that loss. The time of the take is very important to establishing what the value of that property is.
What if it were a completely fair process? However many weeks, months you think notice has to be out there so everybody gets
I think this
it,
is Robert.
easy to visit them, all these things, and you still came out with a price that was below what, for example, the house would sell on the open market, because maybe people don't want to go and get at a tax foreclosure system or whatever. In other words, if you're satisfied with the fairness of the process, and it comes out with something below what you think is fair market value, is that just too bad?
The answer is that the Fifth Amendment guarantees just compensation. It doesn't guarantee the outcome of an auction. And I would point this court to the Lawton decision that says that when a former property owner affirms the selling of the property, they're entitled to at least, and that's, I think, a very important two words, at least the surplus proceeds. This case is distinguishable because—
No, I know this case is distinguishable, but if I think the Solicitor General's position is that you look to the fairness of the process. And what would satisfy you with respect to the fairness? I mean, the just compensation is not out there if it's a period at which there's a Great Depression or whatever, it may not seem fair to you that you have to sell the house for a fraction of the value it was worth before. But what would they have to do to satisfy you that it was a fair process?
In most instances, with well-developed, well-designed foreclosure systems, which we would point to, for example, many of the examples in the National Association of Realtors amicus brief, if those systems are designed to actually get the reasonable fair market value at the time, you're going to have very few cases in which this type of discrepancy, the delta between the actual known value of the property and the auction price—
Well, I guess that's what I'm trying to figure out, the known value of the property. There's not you don't know what it is. One way to find out is have
Okay,
a fair
so
sale
basically
in the
they
open
beefing
market.
and
So
saying,
what's wrong with
hey,
that? I mean, I know you can object to
why
saying, well, there
are
wasn't
you
enough
counting
whatever, it
only the
wasn't enough
auction
time or
price when
but
the fair market
what would it
value is
take for you to
X?
say
But the
that was a
government
fair
is like,
process,
we've
even
always
if it
gone
comes
by
out
the
with a
auction
number
price, so.
that is unsatisfactory to you?
What we would seek is that an auction process is simply one piece of evidence that's overall, in the overall scheme of possible evidence that competing parties could submit to the court to determine what is in fact the fair market value. An auction, in this case, for example, we say the auction price didn't result in the fair market value, and we offer contrary evidence. Courts of this country routinely and regularly figure out and decide what is a fair market value in all sorts of contexts, be it.
Mr. Ellison, I guess I thought from reading your briefs, and tell me if
Kagan?
I'm wrong, that you had agreed that in general foreclosure sales do not produce a fair market value price. In other words, just the fact that even with a very fair auction system, just the fact that a property is being offered for sale in those circumstances means that there's going to be a depressed price. And I think that this court has recognized that in the past. And I suppose I think I'm looking for the same kind of answer that the Chief Justice is. If the auction is fair and it nonetheless produces a depressed price, a price that's lower than the price that you would have gotten 2 years earlier had there not been a foreclosure. Are you contesting that as an empirical matter? Are you saying that even if it's true as an empirical matter, you're still entitled to the free market value?
I think what we're taking is a more nuanced half step from that position. Our position is that we as a property owner should be able to challenge if in fact the auction price reached that fair market value. Some auctions will reach fair market value as a matter of course. Some, like in this instance, did not. And we should be able to present the evidence to say that the outcome, even if it's a fair auction, did not result in a fair market value, which in turn would not translate into just compensation for what was taken.
Mr. Ellison, assuming for the sake of argument that your client got notice of the foreclosure, were there not steps that your client could have taken to prevent landing in the predicament where your client found himself? If you had $190,000 equity in this house, couldn't your client have gotten a loan using that as collateral, paid the taxes, and there never would have been a sale?
In reality is that many times the foreclosure process itself does prevent practically individuals from going out and being able to dispose of that property on the terms that they themselves would do, because we've crossed over into the foreclosure process. This process that we're talking about today is a bit unique in that the actual taking of the property starts before the foreclosure process, before actually taking title. And our position is that the taking of the title itself is what starts that process, and that's the value that it should be on that particular day.
Could you spell out for me step by step what you think the county was obligated to do?
I
So
think
they
this is
foreclose.
Alito.
All right, step number one, they foreclose. And then what?
At that point, there would be what's called a forfeiture, which is a unique aspect of Michigan law. There's a forfeiture. Then there's a foreclosure where they assume and take title, complete
Just
title
real
to the
quickly,
property.
if you are
So they
new
have
to
title
tuning
the
into
property,
me,
and then they pay you the what
men's
you say is the
voices
fair
tend to run
market
together
value
for me,
of the
so it's
property.
sometimes
At
difficult.
that point, the government has two paths in Michigan. One is they can go down and another government can purchase that property for its fair market value, the actual known fair market value, or it goes to an auction process. Our position is that when it went to the auction...
Okay, so then they pay you the fair market value. Is that right? That's what you want.
If it went to the government side, yes. If the government purchased it, correct.
And then the county has an inventory of unoccupied houses, and it has to sell those houses on the open market.
Thank you, Ari.
It would sell them on an auction process, yes. Where we think that the court...
Hey, members.
On an auction process.
They've decided to use an auction process. They're not required to use an auction process.
Well, do you think this auction process produces the fair market value?
This one does not, in all instances, no.
Do you think an auction process generally produces the fair market value?
I think
houses are not usually sold by auction.
They can be. I think it can reach auction value. Speaking from my own anecdotal evidence of my work in Michigan, auctions can reach fair market value, but it
What
didn't
if it
here.
doesn't? Okay, if they use the auction if they use a fair auction process, that's it. They're okay, even if it doesn't yield fair market value. What you say is fair market value.
No, and that's where I was going to just lead
No,
to.
okay.
This is where the shortcoming is in Michigan's system. Is in most typical foreclosure systems, there is a sales confirmation or review process that's done by the court to confirm that it's usually called a confirmation sale. At that point, for example, North Carolina is a good example of this. The former owner can go back and point out either the unfairness of the sale or the inadequacy of the price and say, don't confirm this sale because it doesn't reach fair market value in these circumstances.
Okay, and then what happens?
At that point, the court reviews the competing evidence that's between the various parties.
The court decides what the fair market value is.
That is correct.
You get the fair market value.
I'm
That is
fixing to
correct.
call
And then
this
the
right
county
now.
has to try to sell the house.
That's correct.
And
They ain't
what if
getting it.
They try to sell it on the open market, and they can't get what was estimated to be the fair market value.
Then the Fifth Amendment requires that they pay the difference.
I have
on
to
this
hear
being
the other
just
argument, but
compensation
it's
that's
not
owed.
looking
And all
good
during
for
all this
Pung.
time, they've got this inventory of unoccupied houses. They have to maintain them. They have to make sure they're not vandalized. They have to maintain insurance on these properties.
By the government deciding to collect as a debt collection practice, deciding to use in rem civil forfeiture as a basis to collect on the debt,
If
rather than,
everybody
for
can
example,
just
suing
tap the
or
screen,
going
fill
after
up the
personal
bar a
property,
few
going
times,
after
it
bank
helps
accounts,
the live a
that's
lot.
the obligation that they assume in those in that particular circumstance. Yes.
Counsel, what's your best evidence that historically the kind of procedure you're describing from North Carolina was used? Because it seems to me the historical evidence shows that you were entitled to the surplus of the proceeds from the auction.
The examples are not as many as I would like them to be, but the reality is if we would look to Ballantyne and Grantham as the two types of examples to show that when a sale doesn't reach the ultimate result or a level of unfairness is included in that sales process, that there can be a challenge before the sale is in fact confirmed by the court.
Did you argue below that the process was in any way unfair?
We didn't. We were precluded from that at the 12B6 stage.
You mentioned to Justice Thomas that you think it's, and you kind of get at this in your reply brief, that historically the government had to go after personal property before going after real property.
That is
Did you
typical.
make that argument before the Sixth Circuit?
Before the Sixth Circuit, no, because the ruling of the court below, both the trial court and the Sixth Circuit, is that surplus was categorically the only measure of damages.
Well, it seems to me that why would we get into that? It seems to me a dangerous road to go
Yeah,
down for us.
this
to
is
say
not
that those
boding
things
well
would
for
be
Pung.
constitutionally required
The
when they were neither
justices
pressed nor
just
passed
across the
upon
border
below.
not having this shit.
We would advocate that simply the rule that was developed by the Sixth Circuit below that said surplus is categorically fair market value is in fact too narrow of a rule, and that the Sixth Circuit can deal with these types of what sort of processes and procedures could be built into this to establish a fair process going forward.
That seems to square with what the Solicitor General suggests on page 26 of its brief, where in disagreement with you, it suggests that auctions can sometimes be fine, but you have a right to challenge the procedures. It observes that that is not the basis on which the courts below proceeded. I agree, looking at the Sixth Circuit in particular, they relied on BFP and this categorical rule and didn't get into this. And so the Solicitor General suggests we should vacate and remand to allow those arguments to proceed. I don't see how we could affirm if those arguments were not passed upon below, and there might be an argument that personal property has to come first. But I just want your thoughts on that.
So we share some overlap with the
I want to say that was
government's position in
Gorsuch, but
reversal
it's the
and
morning,
remand
guys.
should be an
Could be
appropriate
Kavanaugh. Who
because
fucking
the
knows?
narrow
I'll
rule
know
the
when
Sixth
I hear
Circuit
the two
adopted
different
of
voices.
Categorical surplus proceeds always equals fair market value. One type of challenge could be a fairness challenge as to the sales process, but that's not the only challenge.
Right. No, I understand you think there are more challenges available, but
Correct.
the government agrees at least a fairness or procedural challenge is available.
Correct.
That wasn't considered by the Sixth Circuit.
We would agree with that position, but we would take it one step further and say, but the fairness of the auction is not the only consideration.
If you were given that kind of remand opportunity, and now I'm
Hagan.
talking just about the fairness of the auction, so put aside whatever other thoughts you might have about things you would like to be entitled to, but just the fairness of the auction, would you have objections on that score?
We would have objections on that score, but those were not developed on this record, given that.
What are those objections?
For example, the Michigan system, for example, is at an auction, you have to, the buyer of that process can't do an inspection of the property, can't go through the property. You have to show up, for example, with cash on hand 2 hours after the sale price itself. This needlessly depresses the market price because it increases risk in that market, which then depresses the price of the property itself.
And that's something that has not been developed, so we would just remand and let the courts below deal with that.
Correct. And we think that both the sale process itself would be one theory that could be challenged. That's not our only theory that we would challenge. We think inadequacy of price combined with many of these unfair factors could then result in a...
Would you also make the argument about the personal property having to come first?
We would challenge, I mean, the other part of this would be, the challenge would be is that Michigan system, Michigan's very unique because it only took surplus proceeds responsibility. It didn't take the back end responsibility, the Ballantine style responsibilities of being able to challenge within the system itself, which is why we're in federal court with 1983 as a supplemental type action to fix that shortcoming.
Can I ask?
I'm sorry.
Is that a yes? Is that a yes that you would, if I might just finish, that you would, before taking the property, one process that they need to consider is taking personal property first?
The answer is yes.
Okay.
The answer is yes.
Right, thank you.
Can I just follow up on that? Because I'm wondering whether or not that kind of concern doesn't.
I'm wondering how they're delineating personal property here. Like, I feel like a house is personal property, but
about, or your claim is that they
I don't
needed
do
to
enough real
other
estate
steps
law, I guess.
before they took the property. I didn't understand the takings clause to be concerned about pre-takings deprivation, that the takings clause was just about just compensation. And so
No, thank you, Noah.
needing to bring a kind of a due process type claim if you're complaining about the personal property aspect of this.
We would acknowledge that due process
No,
comes
this
awful
isn't about
close in
eminent
the
domain. This
just
is about,
compensation
like,
world, but the question that's being
seizure
challenged
of
here is,
homes and
does the
assets?
result of this foreclosure process result in just compensation?
Yes, no, I know that, but I'm saying to the extent in the context of just compensation, we're now thinking just for the moment about what happened before this taking. I wonder whether just compensation is the right analytical framework to evaluate that. It doesn't seem to me to be.
Okay, so while Jackson is going, I'll quickly just kind of go over, like, basically what this case is about. This is Pung v. Isabella County. This is in association to when your home is seized by the government for a debt, right? Like you don't get the fair market value, you get the, auction price attributed to that debt. And then it's also about Eighth Amendment excessive fines. So that's kind of what this case is resolving about. I'm sorry, I wanted to pause it real quick so I could do that.
Account for the circumstances under which this sale is taking place. So we have your client, Mr. Pung, who had this house, but he also didn't pay his taxes. And kind of going with what Justice Alito was saying, piggybacking on it, I suppose there are things he could have done to cover his tax bill. So the government is coming in at the beginning to foreclose on this house for the payment of his debt. Given that circumstance, I guess I don't understand why your argument doesn't kind of turn the government into Mr. Pung's real estate agent with some sort of fiduciary duty to maximize the value of this asset.
Well, yeah, and that's their whole argument is that, like, well, my house was worth more, why didn't it cover more?
Liability. And if Mr. Pung wanted to get the maximum value of the house to cover that debt, he could have sold it himself and gotten the fair market value on the day that you say, the government came, I think, to foreclose on it. So having chosen
this is not going to go well for him,
forcing the government to sell his house, I guess I'm worried about suggesting that he can come back after the fact and say, no, you didn't do enough to get the maximum price. All they have to do is just give him the excess, of what they sell it for. And that should be the end of it, I think, conceptually. So tell me why I'm wrong about that.
So I'm going to take a half step back and then a full step forward to say that what the Fifth Amendment requires to reach just compensation, if you're going to trigger this process, because there's no obligation to do a tax foreclosure in these. This is voluntary on the part of the government itself.
It's an issue
But only
between the
insofar
takings
as they're
clause, which
responding
is
to
that
his delinquency.
you must be provided
his
just
delinquency
compensation.
is the beginning. Like you haven't
If the
really
government
focused on
takes
that,
your
but
property.
the first thing is, Mr. Pung, pay your taxes. And when he doesn't, the government has several options to try to figure out what to do. One of them is, okay, you have this other property, whether it's real property or personal property, we are going to foreclose on it. If Mr. Pung says, please don't, because my house is worth $100,000, and if you put it into a tax sale, it's only going to get $70,000, he can sell the house and get the $100,000 and pay the tax bill. The government doesn't care about that.
But
So why didn't he do that?
Well, first of all, he didn't do that because he didn't owe the tax, which has been one of the underlying aspects of this.
Well, we have to assume that for the purpose of this, right?
But I would agree. But the point I guess I would come back to at the start of your question on this would be is that in a tax foreclosure takings context, the obligation of the government under Cherokee Nation is to have reasonable, certain, and adequate provisions to reach just compensation.
Right, and the just compensation is the difference between what the government was forced to sell his house at on the tax sale and what he owed in taxes. So they gave it back to him, right? They sold it for $70,000 or whatever it was, gave it back to him, and I would think they're done. You're saying they had an obligation to not sell it for the 70 or to reach into the public fist and pay the difference between the 70 and what it would have sold in a fair market scenario, and I don't understand where that comes from.
I'm not paying that shit.
Where it comes from is the obligation that if you're taking property, which is here, the property interest is not the auction proceeds. The property interest here is the value of the equity that was taken.
One last time, they're not taking property like a person like a government who wants to build a railroad. The government wants to have a sidewalk or a park. They're taking property because he didn't pay his taxes. And so to me, that context makes the just compensation analysis different.
Respectfully, I would say that
you disagree.
I disagree. Okay. I guess I would finish by saying is that takings law doesn't turn on moral fault, and the reality is the balance.
But I thought we were doing just compensation.
Well,
there is equity in this.
But the balance of the fairness was decided at the adoption of the Fifth Amendment. The trade-offs between the government and the citizen was already weighed, and the obligation was put on the government by putting just compensation obligations on the government itself.
Thank you, counsel. Justice Thomas, anything further? Justice Alito?
Let me come back to the point that Justice Jackson was just making. Typically, if a property owner doesn't pay real estate taxes, the jurisdiction will send a notice and say, you didn't pay your taxes, and maybe they'll send several, and they'll warn, if you don't pay your taxes, we can foreclose on your property and sell it at a tax sale. Now, before any of that occurs, I still don't understand why the taxpayer cannot, a taxpayer who's in a situation like your client, and again, assuming there was proper notice here, take steps to prevent a tax sale from taking place.
You'll never get me to agree with Alito, but I generally would agree with him on this, that the government will be sending you those notices,
a loan,
bro,
using your equity as collateral.
you had every ability to go sell it previously
There is
if you wanted that full market value.
Can try to do. In fact, Mr. Pung tried to do that in this case in numerous parts with interactions with the tribunal, with the tax tribunal, and things of that nature.
Wait, but I thought he didn't know the tax, so which is it now?
If they cross that Rubicon, if the government takes that property.
Yeah, but before the government takes the property, there are steps that can be taken.
But if those steps aren't taken for whatever reason.
Well, if the taxpayer doesn't take them for whatever reason the taxpayer has, then perhaps one shouldn't feel so sorry for the taxpayer when the tax sale occurs. There are a lot of outfits that will buy houses sight unseen for cash.
I guess
Isn't that another option?
I don't think that's another option because, if Mr. Pung didn't want to leave his home, The ability, this is the home that he wanted his
But that's
nephew's
what
son
happens
and his
when you
family to
don't
be
pay
able
your
to have and
fucking
retain.
taxes.
The
Sorry.
idea that we vacate from the family home because of a tax that's being challenged in this
I
aspect.
mean, I have my
strikes me
own
as not
issues
as
with
being
the idea that you have to like
counterbalance
buy
the
your
equity
property that
we
way,
shouldn't be
but
forced to
still.
sell something that we shouldn't necessarily.
Well, that's another argument about whether monetary compensation is always sufficient to constitute just compensation when there's an emotional attachment to a house, which is a serious thing. But that's not the issue here.
Well,
You
but
can
the
come
issue
up
is
if
here
you want,
ultimately is that there
this
is a
is
piece
hilarious.
of property that has been uncontested by the government to be worth, approximately $200,000. Once the government has decided that it's going to take more property than what the actual value of the debt actually is, that's what triggers the takings obligation. And if it's not a takings obligation, of course, we've also argued it's an excessive fine.
What sorts of personal property do you think the government has to go after first before it goes after the house?
Well, in this case, with a tax debt of about $2,200, it could have been the Peloton bike that was in the house.
You think a Peloton bike today is
What
worth
the fuck?
$2,000?
Well,
if you go on Facebook Marketplace and you try to sell a Peloton bike today for $2,000, I don't think you're going to be very successful. How are they
Maybe
going to
you
know
can
that
get
he
one
has a
signed by
Peloton
Harry
bike?
Sisson.
Traditionally, joking aside, traditionally there are a lot of different options. There are bank accounts, there's personal property, the vehicle. There's lots of.
All right, they're vehicles and bank accounts. Maybe they can find out about that. Other personal property, how are they
So
going to know
true,
what he
Lal,
has?
so true.
I mean,
And they have a right to go in the house and inspect everything and see whether there's a valuable, gigantic TV that might be sold.
When the government is acting in a debt collector capacity, this is what, and when I'm not paid a debt, that's the obligation I have when I'm collecting on a debt from someone that hasn't paid. The government is no different.
If we start to set out all sorts of rules
Jesus.
for these tax sales to make them fair, how many years and how many cases
His
do you
appeal
think
to
it's
heaven
gonna
flags.
take to flesh out all of these details without any historical support for the procedures that you seem to think are required?
We think that the government has excellent models that are already in place that they could utilize. For example, Michigan's mortgage foreclosure process is well established over 100 years. It's already a known market. It's already a known process. They could adopt that on its own and would have the back-end protections that are necessary so that fair market value
Or
is
maybe
reached in
you
all
just
circumstances, whether
sell
it's an
the
auction
property
or a
yourself
post-auction
if you're
shortcut.
worried
All right,
about
thank
it.
you. I appreciate
Just a
it.
thought.
Justice Sotomayor?
I think your fallback position, or your main position, is just compensation under the Constitution requires fair market value.
Correct.
If I disagree with that, and I believe just compensation should be defined the way Justice Scalia did in BDP, which is what's reasonable under the circumstances. And I believe that a valid auction is a reasonable compensation. You lose on your main argument, correct?
We would, if you do not believe that fair market value is the standard, correct.
And so if we believe that a valid auction, and by valid it has to be fair, it has to be permitted. I don't know about the personal property issue at all. I haven't looked into it. It hasn't been briefed, and it's a very bad place for us to make such a huge decision. That would be up to the court below, correct?
Correct.
All right. Now, with respect to fairness, Justice Alito asked, are we going to have to wait for every court to decide what's fair? Or is there a standard of fairness that we can look to, not a particular Michigan, but provide me with a case that talks about what a fair auction for a tax sale would be?
We would point you to 3 cases, in fact.
Oh, my God.
One would be Slater versus Maxwell, which provides that tax foreclosures have to be provided for with entire fairness, and that's the trigger word from there.
I'm not asking you for words. I'm asking you to point me to cases that set forth the parameters of what that fairness would look like.
She's asking him to get to the
high
point.
watermark
Wild.
of tax foreclosure we would point to as a practical multiple factor aspect. We would point to Ballantyne and Grantham, this court's prior decisions, which we have briefed.
Okay, thank you, counsel.
Justice Kagan?
Mr. Ellison, wouldn't your primary position effectively stop states from using foreclosure sales? Because I'm just thinking that if you accept the proposition,
that's
I guess I
exactly
am
what it
going
would
to
do.
ask you to accept the proposition that foreclosure sales usually depress prices so that they're lower than the fair market value. If I have to give you the fair market value, you the homeowner, am I not going to lose money if I'm the state on every transaction like this? I mean, let's take an example. Suppose you don't have this mismatch that you have here between the very small debt and suppose you have an $100,000 debt, right? And a foreclosure sale is going to get you $110,000. And then the state takes the $100,000 that it's owed and it gives you the $10,000 back, right? But then if you say, well, no, the fair market value was really $150,000, so I'm entitled to $50,000 back, right?
Right.
Well, that's just going to cut into what the state gets to take, and it's going to mean that the state doesn't get the debt satisfied.
So my response is that the Fifth Amendment requires just compensation, and somewhat what seems to be baked into some questions today has been whether this is best compensation. But assuming you're hypothetical where
Well, I'm just saying that the state is never going to get satisfied in that situation where a foreclosure sale will lead to less than the fair market value. So the state is going to say, well, we can't use foreclosure sales anymore to satisfy debt obligations.
I would agree they can't use this style of tax foreclosure sale. There are plenty of tax foreclosure sale systems in place that can reach just compensation or even the best compensation in the foreclosure
but again,
circumstance.
I'm coming back to
there are
what is
plenty of
just
foreclosure sale systems
compensation.
that can reach fair market value.
Correct.
Yeah, and I guess I think, how could that possibly be? I mean, if you're selling a house on foreclosure in an auction, you're just not going to get the fair market value as if that house had never been foreclosed on and you were selling it in an open market.
But acknowledging
That seems like common
assumption
sense.
you want me to make, which is the fact that the foreclosure itself can depress the price. They can't depress the price, I think, this far. Now, there could be a factor, it could be a piece of evidence, and we could offer contrary evidence to say, even in this foreclosure type environment, the price that it was actually sold for was not good enough. And this is our Graffin-Ballantyne challenge that's there, that says, in this circumstance, the particular system that the government's created in this particular type of auction sale unreasonably and unfairly depresses the price too far, because we've got this counter evidence, whether it's market appraisals, professional evidence, information, even the government's own assessments of what those values can say what you got at the auction is not enough in that circumstance for that system.
Justice Gorsuch?
Is there something incongruous about the fact that when
God, I
your
hope he
property
gets
is
spicy.
taken
I need this
by
today.
the government to enhance it in a way that's going to increase its value radically? I take a house, I'm going to put a skyscraper on, I'm going to rezone it. The property owner doesn't get the upside.
Correct.
But here we're debating about how much of the downside they're going to get.
Correct. And I would go as far as to say is that this court has always said the government does get the upside. It's a well-established takings law. The problem that I see here is that even if this is not a takings, if we take it out of the takings context and we put it in the excessive fines, what we have here is a government that says for a very small debt, we are going to take and destroy vast majorities of the equity that's valued at the time that we took title to the property itself. So even if the takings part of this doesn't provide the answer, the excessive fines in particular circumstances where the delta is so high here, can provide alternate relief.
And then I do want to understand just a little bit better this principal residence exemption that led to this tax, this $2,200 or whatever it is. You won in front of an ALJ who said that the family doesn't have to pay this.
Correct.
The county then went ahead and assessed it anyway and used that as the basis for this foreclosure.
Correct. So
how did that happen?
I don't think you have a long enough afternoon to explain the story of what happened with here. But the very short version of it is that
was kind of
the
funny.
PRE credit was determined by, in Michigan, we have a tax tribunal that's determines this.
I've read the briefs. I got that. I'm just curious, why would the county pursue a $2,200 debt that their own ALJ said wasn't owed to this extreme?
We can't figure that
That's
answer
been
out.
my
We
question.
don't believe it's due. And the reality is by the time the tax assessor actually informed Mr. Pung that the price was actually, that she had put the PRE credit, had taken it away, that denied it once again, the very limited 35-day window in which a Michigan taxpayer can activate the process of the tribunal to go back again.
After he's already won.
Had already gone.
Yeah.
And so we're in a weird circumstance here where the tax is legally, technically owed, but actually isn't owed in these circumstances. And it's a terrible position to be in for a homeowner.
There is a reason why I picked this case, guys. I know I was
talk about
like
what's just.
citing that it was
I
funny
think it's
earlier.
important. We've been talking
but
about the equities on the government side. I think
the
the fact
actual
that tax isn't
what
owed is a
happened
major
is
equity
pretty
on the
fucked up.
on the property owner side. in this
$2,200, and they foreclosed a house.
Justice Kavanaugh?
On the possibility of remand
The
for
contention is that he
consideration
doesn't
of fair
know.
process, the Solicitor General says, as part of that, the courts below could consider whether and to what extent petitioner has preserved the issue. If he has, he'll bear the burden of showing that the sale was not conducted fairly. Do you agree with that?
We believe that's the first correct step that. At least one theory that can be challenged, but it's not the only theory that can be challenged on a remand.
What are the other theories?
Well, the other theory is inadequacy of price combined to this as well. So, because you could have a sales auction or a sales auction that is entirely fair, but still doesn't reach just compensation.
But do you agree you would have to show that you preserved the issue and that you would bear the burden of showing that the sale was not conducted fairly?
As someone who represents property owners, we always want to put the burden on the government whenever we can.
That's why I'm asking the question.
The court has not spoken to that answer yet, at least as I can see.
You don't necessarily agree. That's fine. I just wanted to clarify what you thought about that. And then secondly, Justice Sotomayor a few times has brought up Justice Scalia's opinion in BFP, and that does speak, as you know, very generally and broadly at the end about foreclosure redefines the market, and given that altered reality, the only legitimate evidence of the property's value at the time it is sold is the foreclosure sale price itself. And I just want to hear your succinct response to BFP and how you distinguish not only the holding, but the reasoning and rationale of BFP.
Of course, the first answer, of course, is always to point to footnote 3 in BFP and say in the Constitution.
Which is a standard footnote, but
he had that footnote ready.
But the question is the rationale and why it wouldn't apply more.
Because in the bankruptcy context, well, two answers to that question. One is in the bankruptcy context, Congress has the given separate authority to reallocate the burdens of debt between private debtor and creditor in those circumstances. This is an Article I, Section 8 question. We're not here on Article I, Section 8. We're here with the government with the takings style claim. So we think that easily distinguishes in that aspect. Importantly, BFP on the facts itself, and I won't get into tremendous detail, but the foreclosure occurred pre-bankruptcy. In California, at the time that foreclosure occurred, they had a challenge process that they could have challenged the unfairness of the foreclosure before it went into the bankruptcy process. And the property owner didn't opt to utilize that process, presumably thinking that the price got fair, and apparently their bankruptcy attorney thought differently once they got in there. So in addition to we're in different constitutional worlds, I think the facts that led up to the foreclosure and how the question was framed before this court got there in two totally different paths and are not congruous.
Thank you.
Justice Barrett?
His argument's
So,
gotten
counsel,
stronger
I wanna
towards the
echo
end.
what Justice Gorsuch said. I mean, it seems like there was some real unfairness to your client. I mean, frankly, reading the briefs, it sounds to me like this tax assessor was like Inspector Javert, but it was even worse because Jean Valjean hadn't stolen the bread. I mean, you didn't even you didn't even owe the tax, and it's this small tax and the big, the big loss of the family home and of the money. So it does seem that there's some unfairness there. But I'm struggling to see how it fits into the takings framework. Can you tell me of a case that we have that treats the foreclosure of a house as a taking? I mean, Tyler
But does it
treats
fit
the
better with
pocketing of the
excessive
surplus
fines
as a
is the
taking.
question, because it's also
But I'm not
something
aware
we're
of a
addressing
case,
here.
I just don't know if it fits this framework. I'm not aware of a case of ours that says that when the government forecloses on the house, as opposed to when it pockets the money, it's taken the house.
The best I can point this court to is Tyler, and I think Tyler was specifically written with the words about value as opposed to surplus proceeds if we look at many of the passages in Tyler itself. What's important, I think, is that historically, under the common law, under debt collection schemes that are developed by states, there's always a back-end protection on
Y'all
the
can
former
just tap
property
the
owner.
screen for
There's
me.
a
It
sales
helps a lot. I
confirmation,
really
there's a review
appreciate it.
process, there's a challenge.
But none of that answers whether it's a taking. Okay, well, let me ask you this question. You say that it should be fair market value. You also say the taking happens when the government forecloses on the property as opposed to when it sells the property at auction?
In this circumstance, yes.
Which is the right date for gauging the fair market value, if there's a gap of a year?
When they take title, when they assume full and complete title, that is the taking, because the person is dispossessed of the ownership of that property at that point.
So the property falls in value, and that's the government's risk.
It is, but it's also the government's benefit if it goes up in value, as Justice Gorsuch points out as well. It's the time, this court has always said we measure precisely at the time of the take is what the value of that property is.
Okay, so let's say I don't think Tyler settles the question whether the foreclosure is a taking, that I think Tyler leaves open and might treat just the pocketing of the surplus as the taking. Why couldn't I view the foreclosure of the house as just an exercise of the taxing power and not a taking?
Because the government is taking more property than necessary to fulfill the debt. Because at that
Well, I
point,
guess
they're
if
no
the
longer a
initial
debt
claim is
collector
that he
anymore. When they've
didn't owe
taken
the
that
tax
much
to
property
begin
over
with.
the debt itself, they've become a confiscatory government now,
But I
as
don't
opposed
think that's
to
the
a debt
claim that's being
collector.
made here.
If a client doesn't pay my bill, I don't get to go seize their whole entire house. I can only collect on the piece of the debt that I'm entitled to do so. Government has different powers. They can act as a super debt collector, and they're utilizing their takings power to be able to take more property than necessary. And when you trigger that taking obligation, here, again, what's taken is not the surplus, it's the equity that's in the home at the time of the taking. That's what triggers the obligation to pay just compensation, because the Fifth Amendment requires it.
Justice Jackson?
Can I just get clarity on the tax isn't owed scenario in this situation? I mean, ordinarily in the tax system, if you have if you're contesting that you owe the taxes, you pay them, and then you go through some sort of process to get refunded by the government. So is that not the case here?
This is I have to acknowledge, this is a unique case in that the tax isn't owed. This is the worst of all examples of government, I think, government run amok on
But
this.
the government says it's owed. That's why they're foreclosing on your house. So the dispute is, I guess, over whether it's owed, and the question is whether it can be collected before that dispute is resolved. And in
Now, that's a
other
good
tax
question.
schemes, it can be.
Correct.
Right. So
Correct.
why can't it be here?
Because Michigan has this very unique system, the PRE, as I was engaging with Justice Gorsuch, the PRE has this very narrow 35-day appellate window that when the assessor says, I'm taking away the PRE credit, you have 35 days, even if you know it or don't know it.
Mm-hmm.
If you don't trigger the tax tribunal's review and that, you're barred from challenging that tax from being, whether it's owed or not owed in that circumstance.
And you couldn't bring some sort of, under Michigan law, a collateral attack on the fairness of that process.
Well, sort of, I'm sorry, I'm going to pause it just real quick. I have to go back to an earlier point, which is like, okay, he owes the 2.2 or is it 2.4K, right? Why would he not just pay that and then ask the government to recompensate rather than them moving into removal proceedings. I need to go back and read through the cert petition again. It's been a hot minute, but I do have that question. Like, say they say I owe $2,000, $3,000. I'm gonna put something together and I'm gonna pay that before I'm gonna let them like sell my fucking house. But again, I would have to look at the timeline again and stuff like that. But yeah. Sorry, y'all. I'm just spinning my thoughts right here. I apologize.
That terrible outcome. I hear you. If there's no notice, there's no opportunity, there's no chance for Mr. Pung to run in and pay the $2,000 so the government doesn't steal from his perspective, his family home. But when the government says clearly, this is how we intend to solve the problem of you not paying your taxes, why isn't it incumbent as a matter of justice for the taxpayer, if they want to avoid the thing the government is threatening, to just pay the taxes in some other way?
I believe if Mr. Pung knew he was going to be at the United States Supreme Court arguing about $2,200, he would have paid that many years ago. But the answer to your question is
that's
that
very fair,
at the point
too.
when the government takes more property than necessary.
I'm before that point. I'm before the taking. I'm at the government threatening to take your house. And when they do that, the question is what comes next as a matter of fairness and traditional tax policy, et cetera. And the reason why I keep getting hung up on your ultimate "this is so unfair" point is because I see a very clear opportunity for the taxpayer, who, by the way, is the original problem because he hasn't paid the tax, to solve the problem. And when the government just follows through with what it said it was going to do because it's owed this money in its view, I don't understand how the taxpayer gets to say it's unfair that the government didn't do all I think it should have done to get my house valued at the highest possible price. And in fact, if they put it in a tax auction, which is just standard, they've got to actually go and pay me the difference. That seems like real unfairness the other way to the rest of the American people, that we are paying you because you didn't pay your taxes and the government had to foreclose on your house.
The best answer I can give you is governments have a lot of tools in their tool chest to collect debts. They can use lawsuits, they can use the Peloton bike example I was using earlier. They have a lot of tools in their tool chest. If they're going to utilize a process that captures way more property value than what the tax debt is, the takings clause does not have a moral fault. The takings clause has balanced those interests already and has put that burden onto the government.
Thank you.
Thank you, counsel.
Thank you.
Mr. Liu?
Mr. Chief Justice, and may it please the court. In Tyler, this court looked to history and tradition to conclude that a taxpayer is entitled to just compensation when his home is sold for more than he owes. The same history establishes what compensation is just. As long as the sale is conducted fairly, just compensation is the surplus proceeds. According to petitioner, compensation should instead reflect a property's fair market value. But as this court recognized in BFP, foreclosed property is simply worth less. Petitioner's approach would defy that reality and spell the end of tax sales in this country. As for the excessive fines clause, it's simply not implicated here. Any taking that's justly compensated for can't be a fine, can't be punishment, and can't be excessive. I welcome the court's questions.
Mr. Liu, you seem to put a lot of weight on fairness of the process. How do we determine that? Do we look at history and tradition? Do we look at, as petitioner argues, at least
You're
as a
looking
part
at
of
history
the
and tradition to determine
end
fair.
result, whether or not the
Yeah,
price is fair market value? What should be our gauge for that?
I do think we look to history and tradition to determine what a fair sale looks like. I think some helpful guideposts are the Cooley Treatise starting at page 334 that goes through the historical practices of jurisdictions at the time. I think the federal government's 1812 statute is also a helpful guidepost. And I think if you look at those guideposts, there are basically three minimum ingredients of a fair sale. One is public notice that contains
Well,
the
women
time and
couldn't
date
own
of the sale,
property,
description
so
of the
they can't
property.
foreclose on
The
my
second
house,
is that
guys.
there must be a
History and
public
tradition.
auction. It can't be a secret sale. It can't be a private sale. And the third ingredient is that
Sorry, that's
the
just a
auction
joke.
must be competitive. There must be an opportunity for bidding and sale to the highest bidder. And of course, you can also look to history and tradition to also figure out what is the amount of the tax debt that can be subtracted from the sale proceeds to yield the surplus proceeds. But do I think the inadequacy of the price bears on that? I'm not going to dispute that a truly grossly inadequate price should cause a court to look more closely at the procedures. But the fact that the price is inadequate is not alone enough to justify setting aside the sale, and it never has been for the centuries that tax sales have been conducted.
Has the taxing authority and power of government superseded that of the constitutional right to private property?
No, I don't. I mean, if I'm hearing the question correctly, no. The government's authority to foreclose on property doesn't supersede any private property rights. I think what the taking clause reflects is a really important guarantee of what happens when the government does take property, and it's the guarantee of just compensation. That's the balance the founders struck.
Are there more protections in mortgage foreclosures, for example, than there are in tax foreclosures?
There may well be. If you to contrast some of the cases my friend cited, he cited Gresham and Ballantyne. I mean, those were not tax sale cases, and they did mention this concept of gross inadequacy of price. If you look at the court's on-point opinion on tax sales, which is Slater versus Maxwell, the court rejects the notion that tax sales could be challenged based on a mere inadequacy of price. So
that's not what I'm not talking about. That it seems as though when we talk about such things as mortgage foreclosure,
I'm just saying this is a lot of talking for Thomas.
But there are all sorts
He's
of
serious.
built-in protections
right.
For the homeowner. Are there similar built-in protections for the taxpayer in tax foreclosures?
I think there are, but I don't think they're constitutionalized by the takings clause. I think federal and state statutes have long proven perfectly capable of protecting the process and exempting certain property from levy in the tax sale context. And so they've provided the protections that may exist outside.
I think my point is rather that you're looking at a contract, a private contract, when you're looking at mortgage, and there are these built-in protections. You're looking at a constitutional right as with respect to private property as it relates to the government. It seems as though that if you're looking at protections, they should be at least similar.
Yes, and I think it's a pretty good sign that the tax sale procedures are constitutional in that they provide the tax sales that are conducted
if he wasn't
by governments look very
morally
much like
reprehensible
the
to
private
me, I'd want him to read the
foreclosure
audiobooks.
sales that
I love his
banks and
voice.
private lenders conduct.
You say that we should vacate and remand, correct? So we can't affirm because none of these arguments about history were developed in the Sixth Circuit. They just went off on the idea of the foreclosure sales automatically good enough, and you don't support that view.
Correct. We think the right way to go is vacate and remand for consideration of any
I couldn't tell who I was listening to just
And
then.
there really would be any arguments about what history and tradition might require, in your view, that they should consider, that are preserved.
Exactly. So long as they're preserved, all of those arguments can be considered.
So, for example, Cooley also says, take more property than you need to, right? That's another rule. that might
Okay.
be,
Thank you all. That was my
problematic.
instinct,
That
but
is certainly
it's
fair
been a
game.
morning.
And they
My head
say,
is
you know,
confusing them.
if you can take the Peloton rather than the whole house, you should take the Peloton. And I mean,
If it's preserved, that could be considered too.
all right, thank you.
Position on whether those things are required? You're
Barrett.
just saying if they're preserved, they can be litigated below. Do you think they are required?
I don't think they're required by the takings clause. To take the personal property hypo, there's no need for such a rule that says the government needs to exhaust the personal
Well,
property.
if you want to play with history, if you want to invoke history,
Yes!
you can't cherry pick it, Mr. Lou. And
My
you know,
God,
the history
he's
there is
my
pretty
favorite
clear
spicy
that,
judge.
You know, Cooley's. If you invoke Cooley, you got to eat your Cooley. It seems.
Yeah,
to
so
me.
I read Cooley differently. I know
Okay,
that-
all
I
right,
know the
that's
passage.
fair, but you would accept that you have to deal with the whole of the history. You don't get to cherry pick your.
Oh, of course. And that passage from Cooley is a rule about divisible property. What it says is when property is divisible,
Love that
the
man
government
sometimes.
shouldn't take more of the parts than it needs to. Now here, the property was indivisible, and everyone agrees that it was necessary to take the whole property. You couldn't take just the backyard or just the front yard, and so that rule is simply inapplicable.
Well, how about, Mr. Liu, a rule that would say there's the house, but there was also a car, and the car could have satisfied the $2,000 debt?
We don't think the
was
takings clause
Kagan.
constitutionalizes that rule. We think the takings clause doesn't address the antecedent question of what property can be taken for public use. Rather, it addresses the subsequent question of if you take property for public use, what is the just compensation? But
Okay,
I
but
just want to
shouldn't
address the
property
merits
taken
of this
be
personal property exhaustion
appropriate?
rule. There's no need for such a rule because
Like, why take
if
a
the
house if
taxpayer
you could
wants
take
to
like a
sell his
car?
Peloton
You
bike
know,
to
maybe it's
satisfy
just
his
me.
tax debt,
I don't
he is
understand
free
real
to do
estate
so
law
any
enough for
day of
this,
the
but
week. In fact, our foreclosing on it would make it more difficult for him to sell it. So if indeed Mr. Pung thinks the way to satisfy my tax debt is to sell my Peloton bike, there's no need for a rule that forces him to do that.
Well,
And
what if the only thing he has to sell is his house?
if the only thing that he has to sell is,
He doesn't have to do that, does he?
well, he can sell his house, and he's free to do so to pay the price. If it's a situation where there's a financial hardship or it's
Well, what do you mean if there's a financial hardship?
well, in Michigan,
It's usually not a defense to paying your taxes.
no, but in Michigan and in many other jurisdictions, taxpayers who truly are unable to afford their taxes are given installment plans, offers in
I was
compromise.
saying that was Alito, but
They're
Again,
given
what if the morning?
opportunities to.
Oh, sorry, go ahead.
Oh, they're just given opportunities to find a way to pay their taxes. And one of them is indeed to ask in the case of the IRS, to discharge the house from the federal lien so that the taxpayer can sell it. And what happens at
thank you,
closing in
Law.
that open market sale is they simply cut a check to the IRS.
Well, what if the validity of the tax assessment is still under challenge?
So if it's still under challenge, under the IRS rules, we cannot levy on the house. So that challenge can go forward. I think what's unusual about this case is that instead of paying the tax and then challenging it,
honey,
Mr.
if
Pung
you got
just
Harry's
wanted to
system to
litigate
sign it,
all the
maybe
way
you
through
could.
without
I don't
paying the
know.
tax at all.
Thank you. Justice Thomas? Justice
I'll
Alito?
keep talking shit.
There are some suggestions in the many briefs that have been filed in this case, although not in petitioner's brief, about specific things that could be done to make the process fairer. For example, one of the briefs points to statutes that have been enacted in Oregon, Maine, and Massachusetts, and they say that under those statutes, the jurisdiction that is attempting to collect the taxes must first list the property for sale at market value via real estate brokers or real estate agents, and then if the realtor listing is unable to proceed, then a public auction is allowed where the minimum strike price at auction is 2/3 of the fair market value, et cetera, et cetera. So some of those things seem like possibly good reforms that would make the process fairer, but what concerns me is getting into the determination of which the details of this scheme that are minimally necessary to comply with the takings clause.
We share that concern as well, Justice Alito, and that's why at the outset, in response to Justice Thomas's questions, I provided a few things that we think provide the constitutional floor. But above that floor, I think states have leeway to adopt other procedures that in their view may or may not close the gap between
States' rights.
The forced sale price and the fair market value. But it's up to them to adopt those.
Justice Sotomayor?
That's the problem, Mr. Liu. Because you get into a situation like this one that Justice Barrett very eloquently described as feeling like fundamentally unfair. They're fighting over a $2,400 tax debt that at least 2 courts said wasn't owed, and yet they plowed ahead and got a price half the amount of the value of the property that was flipped for the value of the property. At some point, doesn't the Constitution have something to say under the rubric of what a just compensation is? Is it just to give the state that much leeway? Shouldn't the minimum require a little bit more?
I don't think the takings clause speaks to those issues. I mean, to the extent the
So what would?
Well, I think these sorts of issues about when a foreclosure is appropriate have typically been the province of federal and state statutes, and those statutes have proven perfectly competent in addressing those issues
Not here.
for centuries.
Not here.
Bullshit,
That's
she
the
said,
claim.
not here.
Well, I think what the facts of this case show is that Mr. Pung was given notice of the delinquency. I mean, he face-to-face was told by the township assessor that he owed the tax.
And he went to tax court, and the tax court said, no, you don't. And he presented the government with that notice, and the government said, bye.
Right, and I think this is an unusual feature of this case, that while Mr. Pung did appeal the denial of the principal residence exception as to certain years, he didn't appeal that denial as to the year at issue here. I don't know what explains that choice, but it is what
All right, I have one
creates this
final
case.
question. Given the 3 minimums of fairness, are you saying those are the only ones, or are you leaving open the door that there are potentially others?
We are leaving open the door that there are others. I think, as has been mentioned this morning, this is not an issue.
Here's
that
a
has
crazy
been the
idea.
focus
Maybe
of
we
the
just
briefing.
shouldn't have to, like,
So,
basically
one of the
fucking
reasons
lease
we
our
think
own
a remand
property
is
from the
appropriate
government.
is for any
Just a thought.
preserved issues like
Like,
this
once
to
we
be
pay it off,
addressed.
it's paid
The
off.
reason why I say it's not an exhaustive list is because while there are certain procedures that you can point to that will provide fair procedures, there's any number of things a state could put on top that would actually make those, undercut those same procedures. So I don't think it's as simple as going through and saying there's X, Y, and Z. I think you need a catch-all, and that's something like, and the state can't do anything else to kind of undercut all the procedures on that list.
So the other side is saying you can't do anything that undercuts fair market value.
I mean, I
That's
understand the
how they would
benefit of
answer that
property
question.
tax. I'm not
And so how should we
underweighing
answer
that.
it? Not
I know
that
it helps
way.
schools and
Right,
communities.
and I don't
It
think
does seem fucked
the
up.
mere fact that a procedure is or is not going to have an effect on fair market value can be enough to decide whether it's okay or not.
But should it be a factor?
Whether the procedure undercuts fair market value.
In some
Yeah.
not rational way, or I don't know what
I think the guide has to be history and tradition. I think that provides the most principled way to decide which procedures are required and which are not.
All right, thank you.
Justice Kagan?
Just as an empirical
Sawyer's
matter,
a lot
Mr.
more
Liu,
boring.
do
I
you
ain't
think
even
that
gonna
Justice
lie.
Scalia was right when he said the thing that Justice Kavanaugh read, that foreclosure sales just produce not as much money as the fair market value would?
Yes, we think it's just a matter of basic economics. It's been proven true through histories, centuries of
Generally,
experience
that is how
with
it
tax
works.
foreclosure
That's
sales.
common
And petitioner
sense.
indeed acknowledges on page 20 of his brief that forced sales inherently lead to lower prices.
So what would it mean if we said that the measure was fair market value with respect to foreclosure sales?
It would spell the end of tax sales in America. Every tax sale is necessarily going to yield less than fair market value. If the government is nevertheless required to reimburse the taxpayer as if the sale yielded fair market value, then every tax sale is going to end up costing the government money, and it won't be long before governments simply stop conducting tax sales altogether. And at the end of the day, who does this hurt? It hurts other taxpayers who are actually paying their taxes, because the shortfall has to come from real taxpayers.
Thank you.
Thank you, Ken.
Mrs. Gorsuch?
In that analysis, I'm sure there are a lot of careful economic work done that probably quantifies the delta between fair market value and what a good auction price after foreclosure looks like. Would that be relevant consideration in this process that would happen on remand? The evidence about what, in fact, a good process tends to yield?
I think that sort of analysis can be an indicator.
Right.
It can be a reason to look more closely at the process. After all, I think the historical guarantees of notice and publicity and competition are there to make sure. When you don't have those, what happens is that the price goes down. So conversely, if you see a very, very, very low price,
like here,
you might wonder about the
basically
procedure.
a third of the market value was realized.
Oh, Everett, eminent domain is a whole bad boy I just don't have enough knowledge on.
Were fair.
Ask Lowell,
I think
he's in the
pretty
chat.
skeptical is too strong. I think it is reason to look at the procedures and to scrutinize them.
I suspect it's a great deal lower. I don't know. I haven't done it, looked, and maybe you have, and you can tell me. But I suspect 1/3, or approximately, is a good deal lower than a fair process tends
Yeah,
to
I
yield
agree.
compared to
Tax
fair
law
market
is
value.
overly
It's hard to
complicated and
generalize
absolutely
because,
ridiculous. I would
in
love
response
just
to
a
Justice Alito's
baseline.
question, I do think it's true that states have some leeway in the types of procedures they adopt. So there's going to be state variation.
Sure, a lot of people may just let the whole thing go to seed, not take care of it, not keep it up, and realize as little as possible, not notify anybody about it. Others might actually care, you know, and take care.
I can tell you the IRS estimates
Mr.
a forced
E,
sale
the
like
government
this,
got their
to result in
$2,400 back.
60%.
of what the quote unquote
That's
fair
who
market
benefited
value
from that
Thank you. That's
sale.
very helpful.
Nobody
Thank
else
you.
did.
Justice Kavanaugh?
Do you think our opinion in this case should talk about the procedures at all, or any of this?
No, I think it's enough for this court in this case to simply articulate the correct principle, which is as long as the sale is fairly conducted, the surplus proceeds represent just compensation, and fleshing out what a fair sale looks like can be left for
I'm
remand or
super
for another
torn
case
on
if the
this.
issue
This is just such a
preserved in
fucked up
this one.
situation.
We
It's
shouldn't
hard
even
for
say the
me.
guideposts that you mentioned in response to Justice Thomas.
We're not urging you to do so. We acknowledge that the precise guideposts have not been the subject of adversarial briefing. That's not that I don't believe that they are the correct guideposts, but there just hasn't
We
been.
can make a mistake, is your point.
There just hasn't been the airing of what those procedures are that I think would warrant this court getting that granular about what the Constitution requires.
Thank you.
Mr. Lowe, I just want to ask you about the right analytical framework as we think about the opinion. This is an unusual case, and as I was kind of going.
I'm sorry. Sorry, guys, real quick. I'm going to pause real quick. Law, if you're still in here, I got a question for you. If the government takes your property and claims like eminent domain, do they have to give you a fair market value? Like, is that how that works if they take your property then? just curiosity, because I'm wondering, like, because Everett keeps bringing it up, and it started getting me thinking, like, we have a case where this property was seized, and they're alleging they didn't get fair market value. But if the government does it that way, do they have to give you fair market value? Does it violate the takings clause? And then I would ask, does it stretch to this? And sorry, I'm just spinning my wheels, but I'll get back into Barrett. Sorry, guys.
The taking occurs at the time the house is foreclosed upon, not at the time of sale, which could be a different time period.
But you might not know if there's extra value in the house, because if the government is saying so long as the sale is fairly, I mean, here there was a huge difference between the debt and the value of the house. Let's say it's a lot closer. Let's say the debt was, $90,000, and you don't know how much the house is going to get at auction. So then, did you take the house at foreclosure?
It's true. Without doing this sort of sale analysis, you might not know. But that's also true, and even to a larger extent, under petitioner's test, because their test is hypothesizing a fair market sale and then reasoning from that there is excess value. All I'm saying is what you would hypothesize at that moment is just a different kind of sale. You would hypothesize a distressed property sale, and if your hypothesis is that that would result in more than the tax debt, then I think you have a good indication that there is a taking at that moment. Now, of course, the actual sale that happens is going to confirm exactly what the surplus proceeds are. But I don't think there's any real analytical problem in thinking that the taking occurs at the time of foreclosure. But I should also add that timing is going to be dependent on the laws of the jurisdiction. So here in Michigan, the judgment of foreclosure,
There was a gap.
There was a gap, and then the sale happened. Under the federal scheme, the taxpayer's right of redemption goes beyond the sale. The taxpayer has until 180 days after the sale to say that he wants to redeem the property and take it back. We would say under the federal scheme, there's no transfer of title and therefore no taking until that right of redemption expires. And that's traditionally how I think courts have understood the property rights here. The transfer of title coincides with the expiration of the right of redemption.
So the right of redemption is where the expiration of the right of redemption, it's not quite, let's see. I'm not an expert in foreclosure by any stretch, so I don't know how all these steps work. But if I'm understanding you correctly, it's not really at the moment of foreclosure, because the right of redemption might expire at a time later than that.
Exactly. And technically under Michigan law, I think there's still, you have until the following March 31st or 21 days after a contested foreclosure.
So you're not really pegging it to when the government exerts control over the property. You're pegging it to when the property owner has lost any ability himself to control the property.
Correct.
Okay, well then that would be different. When we started talking and I said foreclosure, you are saying analytically I should be thinking of this differently.
You're right. I was using foreclosure as a sort of shorthand for the transfer of title. But you're right, as a technical matter, the judgment of foreclosure doesn't necessarily coincide with that transfer of title.
Michigan be running a racket,
that is key. And that may vary depending on the jurisdiction.
Okay, that's helpful. Thank you.
Justice Jackson?
Really quickly, do you have any reaction to the thought that all of the fairness questions that are coming up in this case could actually be taken care of in the due process realm? So what I mean is that we have this the fairness questions about whether the government should have taken personal property, Michigan government, personal property before the House. That's one set of issues. Whether the Michigan government conducted a fair auction. You all are accounting for that in the context of the just compensation evaluation, but I suppose you could say just compensation is the amount that is generated at auction minus the tax bill, which is what we're calling the excess proceeds. To the extent that your argument is that they didn't do enough with respect to the auction, what you're really complaining about is what Michigan law says about the process And we have a whole set of cases and ways to evaluate whether, as a constitutional matter, the government is giving you adequate process. So it takes care, I think, of like some of the concerns about, well, how do we do this, and figuring out whether it's fair enough. We have a rubric when we look at federal and state laws and they're giving process to people in a context. We say, as a constitutional matter, is this procedure comporting with due process? So what is your reaction to treating it like that, in which case we would affirm, because the Sixth Circuit is doing the takings part of this, just compensation equals excess proceeds, and leave open the idea that there could be another lawsuit by this very plaintiff claiming a due process problem?
I don't think we have any real objection to putting the fairness of the sale under the heading of procedural due process.
Yes.
I think what matters most to us is getting the contours of that rule right, and I think whether it's viewed as procedural due process or
Oh my
a function
God,
of the
he's
just compensation
lame. Change
clause,
the record.
it's
This
still going to
song
look at the
sucks.
same legal materials. It's still going to look to the nation's
Sure,
history and tradition.
absolutely. But it just helps that we already have a way of thinking about whether state laws are giving people adequate process. It seems like, you know, to kind of import that here seems to be difficult, and that's what a lot of people are reacting to.
Well, I guess all I would say is there's, I think, a common sense intuition that if a sale is rigged or there's collusion in the sale, that what results from that sale isn't really just compensation.
Sure, but the state law is doing that, and we can evaluate whether the state law's process is generating artificially unfair, depressed auction prices under the rubric of, are they giving you adequate process?
That's right. And the only thing I would really push back on, though, is the idea that some of these other rules about the government's authority to foreclose and what it can foreclose on, I don't think there's a home for those rules under the rubric of, I think it would have to be substantive due process.
Fine. Thank you.
Thank you, counsel.
Rebuttal.
Mr. Nelson.
Mr. Chief Justice, and may it please the court. The petitioner's takings clause question here has morphed from just whether fair market value is the only measure of just compensation into questions regarding whether the takings clause requires the government to execute against certain property before others when collecting a debt, and whether the takings clause dictates the procedures for government auctions of foreclosed property. Only the first of these questions was actually preserved and addressed below and challenged in the district court. The Sixth Circuit here correctly applied historic practice, this court's precedent, and economic reality to determine that surplus proceeds, from an auction sale, less the tax debt that's owed, establishes just compensation. Property sold under in a compelled market, under compelled market conditions, is worth what the market pays for it under those conditions, and not what the property would be worth in an idealized private sale. By contrast, petitioner's fair market value theory has no foothold in historic practice, this court's precedents, or economic reality. Even though the government has been selling properties at auction and returning the overplus for centuries, not a single case has ever suggested that the surplus proceeds are equal to the property's fair market value less the debt. Moreover, the petitioner's fair market value approach assumes market conditions that simply don't exist after a foreclosure because the property owner's decisions not to pay the tax, not to sell the property, not to obtain a statutory deferral, and not to exercise the right of redemption. The takings clause does not require compensation to the owner for owner-created reductions to the property value. That would be unjust to the government and to the public. I welcome the court's questions.
What was the assessed value on which the
Why are we
tax
having
was
three
imposed?
people in this one?
The
God
assessed
damn, I
value
thought that
here
we
was
were going into
approximately
rebuttal. Fuck my life.
$194,000.
Can petitioner use that as a basis for its
I should have looked at the
disagreement
lineup.
with
My
the,
bad,
foreclosed
guys.
sale value?
Justice Thomas, we do not believe so because if the measure of the property's value is at the time of the taking, it's either if the taking is the surplus proceeds
then the amount of the surplus proceeds is what's taken. If the property value is the equitable interest in the property at the time that
I
the
agree,
right of
Law.
redemption
Hold on, let me
expired,
go look up who this
the
is.
property was no longer worth the assessed value under market conditions because the property was in foreclosure and the right of redemption had not been exercised, such that the value of the equitable interest in the property had diminished to a forced sale value, which we believe is the teaching from BFP.
So the value decreased approximately $120,000 in that short period.
We believe that the property, yes, the property decreased in value by a very significant amount between the time of the assessment and the time of the foreclosure, or excuse me, the expiration of the right of redemption because of the non-payment of the tax. No reasonable buyer out in the market would acquire the property at the moment of the taking here for the $194,000.
Except for someone did shortly after the auction buy the property for the prior $194,000.
Oh my God, we literally
Doesn't
had
that
somebody
give
from the
rise to
Solicitor
some
General's office
reason to
arguing.
be concerned about the procedures that your client used?
No, Your Honor. The procedures here have been the historic process that have been
My
used
bad, guys. I
since
should have
the
looked that up.
beginning of the Republic.
They weigh in
But
on
with
some of
regard
the
to
weirdest
particular
shit sometimes.
$195,000 subsequent sale price, what we have is right now a discussion of the assessed value of the property on the open market and a later sale of the property more than a year after the property was purchased from auction, also on the open
Hold
market,
on.
and not a sale.
I believe
within
it
the
said
confines
US, but let
of
me
a
double
forced
check.
sale with regard to the property. At the time of the foreclosure, there was no longer an open market for the property. We could not. There was not an unlimited time to purchase the property, and there was not the opportunity for there just to be a willing seller.
I am curious. I know it's
Yeah,
a bit of a sideshow.
Lou,
I
Assistant
apologize, but I am curious
Solicitor General for the
about
Department of
how
Justice.
come the assessor charged that tax again
Oh, my bad,
in
guys.
disregard of the ALJ's, at least oral indications that it was not owed. And how come nobody over the many years between there and here said, hey, wait a minute, what are we doing over a $2,000 tax bill?
So, Justice Gorsuch, there are a couple of wrinkles that occurred in this process. Number one, the decision with regard to the personal residence exemption was made by the township assessor, not the county. So the township assessor disallows the personal residence exemption. The property tax remains unpaid. The property tax is delinquent. So the property gets turned over to the county treasurer for the collection of the tax.
I understand that there are a lot of bureaucracies involved and that the right hand's not always talking to the left hand. I appreciate that. We've all encountered that phenomenon. But what is curious to me is we're sitting in the Supreme Court of the United States many years, no one, at some point the right hand recognizes, there's a left hand over here. And at some point, a lawyer gets involved and advises the left hand to the right hand. And I'm not criticizing anyone, don't get me wrong. I'm just curious how a $2,000 erroneously applied, it seems, $2,000 tax bill led to taking someone's home, a sale for a third of what it's worth, and then very promptly the whole value is secured again by the person who collected it out of the foreclosures. It's a striking set of facts.
Banger.
How did it happen?
So the township assessor, I don't know what the township
assessor's
reasoning was. It may well be. There's two requirements with regard to the principal residence exemption. There must both be, the person who's entitled to it must both be the owner of the property and be using the property as their principal residence. There may have been a question with regard to whether it was being used as a principal residence at the time.
Because Donald Trump wants to be able to
with
take your
regard to
property,
after
Kim.
the property is turned over now to the county,
They told
who
me
is
so.
the respondent here. When it's turned over to the county has no authority to say, now this tax should not have been paid, unless what happens is...
Oh, goodness. Really?
Unless...
nobody can say, hey, there was a mistake.
Well,
I have to foreclose on someone's home for a tax bill I now know is false, but I'm forced to do it.
So Your Honor, the petitioner here had the opportunity to come to the show cause hearing or the foreclosure hearing in the show cause hearing with the treasurer or the foreclosure hearing with the court and say, this tax was never properly assessed.
Spicy
At
Roberts
that
is
time,
just
there
on
is an
fire today.
opportunity to say the tax is not properly assessed. We're going to go ahead and reverse this whole process, and we're in the clear. But that didn't happen.
Is this always how the county does it? I mean, if the
Barrett.
tax bill were $100, you would still take a house?
That fucking part. Thank you. Thank you.
Typically, if the
Sorry,
property
guys,
tax
like,
bill is $100, that
drives me
means the
nuts.
assessed value of the property is very small. So yes, there are instances where there are very small assessed value or very small tax bills with
It was less
properties
than,
that also have
I think,
lower assessed values.
$2,500. That's small compared to the price of a
I find it
house.
strange here that every other tax year was paid. Don't you think by the time of the sale that the county would have said, wait a minute, every other tax bill has been paid, something went awry here?
I think they were well aware of what went awry, that there was something that had gone awry in the situation, and this particular issue that had gone awry is the tax bill.
Yet they still sold the
that
fucking
had not
house.
been challenged, had not been paid, even
I've
though
been,
the others-
well, I do have a question, and Mr. Liu's answer raised it in my mind. It's one thing to say that an auction price reflects the just compensation. When
IMO,
it's
if
close
some sort
to
of
or at the
active
time
challenge is
of the
going on,
taking.
I don't think that they should be able to
But once
sell
you
that property
separate
until
out
after it's been
the
settled.
point of just
Just
compensation,
my
which is
opinion.
when you've taken.
Not saying that's the way it works,
which you
my
seem
opinion,
to
though.
agree. It's the time you took title, and let's assume Mr. Liu's answer, and no redemption, and redemption rights have expired. What permits you to hold on to that property until it secures the lowest value? Meaning, I can assume that just compensation is just as an auction price if the auction is close to the taking. But if it's not, how do I make
I
that
agree, it is a state's issue, Ken, but
Two
they,
responses to your question.
two
Justice
things came
Sotomayor.
up here,
First, with
which is in
regard
regard to the
timing
takings
here.
clause and the Eighth
timing
Amendment
here was somewhat
excessive
unusual
fines, which hasn't
because
come up
the
as much as
actual
I wanted
foreclosure
to,
was
so.
challenged. And so there was multi-year litigation all the way
Opens
through the
that
Michigan
door.
Supreme Court with regard to the underlying foreclosure. So the
I will
foreclosure
put
was-
that the foreclosure, the taking is when that finishes. Okay.
So when the foreclosure judgment was reinstated, there was a period of time for redemption, and there was not enough time to notice the property for the next regularly scheduled auction for these properties. So the counties hold two auctions for these properties, one in July.
Yeah, but if there's
one in
something
July or August,
declaratory
and then one
that
typically in
regulates
September or October.
how
That
you
is the
can
normal
deal
process.
Do you
with
know what the
certain
historical
properties
practice
in
was
regard
on
to
this
certain
issue? Was the
situations,
historical
this could affect
practice
federal
come
issues,
more that what happens in
I would think,
federal lien law?
especially if it's
or
in
is this
regard
a
to
new
takings or
creation
Eighth
by
Amendment.
states, that they foreclose, keep the property as long as they want, and sell it when they want to?
No, Your Honor, I don't believe there's anything that I've seen with regard to specifically how long after the foreclosure occurs that the auction sale must happen.
That's one of the
But
things
this
that
is-
hasn't been briefed, but it is an important question in my own mind. All right, thank you.
Well, Mr. Liu seemed to suggest that, and maybe I misunderstood him, but that if the taking occurred when the right of redemption expired, that would be the relevant moment for valuing the property, because that's how the Fifth Amendment works, and, as applied to the states too, that when the property is
There it
taken,
is.
that's when we value it. So kind of picking up on what Justice Sotomayor is saying, I had understood Mr. Liu's answer to be consistent because he was saying, well, you would kind of make that judgment about what it would get at auction at the time the right of redemption expired. But I understood you to be telling Justice Sotomayor something different, which is don't worry about that date.
They just
We
create
still
precedent.
treat it as
They
being worth
wouldn't
whatever
be
the auction yielded, even if
pushing
it's a
them
year
to do
later.
anything. See
Justice
Roe
Breyer,
v.
no,
Wade
Your-
for that
no,
one.
I'm sorry if I created some confusion. If the taking is at the time the right of redemption expires, and that's not true as a matter of Michigan law, so I want to come back to that. But with regard to if that's what the taking is, then yes, the valuation is as of that date, and the auction is as BFP suggested, the best evidence of that. If there is a significant delay, that might be something that would call into question whether the surplus proceeds are generated are the accurate reflection. Here, there's a reason for the delay. But with going back to some of the questions you were asking earlier of Brother Counsel, under Michigan law, under the Raffaelli decision, the taking is deemed not to have occurred until the surplus proceeds are generated. And so, as you were indicating earlier, there's an exercise.
I mean, when a taking happens is a question of federal law.
When a taking happens is a matter of federal law. The definition of the property interest is typically a question of state law, and as long as they're not defining away a pre-existing property interest, state law, my reading of this court's jurisprudence is that state law would then govern. Here, the Michigan Supreme Court has said it is the withholding, that it is the right to the overplus when the overplus is generated that is the relevant time to assess the taking.
I can see that as an argument about measure, but I don't see how that's an argument about what the taking is for purposes of federal law.
Ooh.
So I would have thought that when I lose all the bundle of sticks in my property and the state takes them, that's a taking for the purposes of the U.S.
Yes, it is. Thank you so much.
Whatever Michigan might say.
And that is consistent
Fuck
with
you,
the
Michigan.
Sixth Circuit's decision in Hall. There it would be the equitable interest in the property as distressed by the fact that the property is in foreclosure and there's the right of redemption.
Once title is passed, I mean, would you agree that once title passes to the county, to the state, that is the date of the taking for purposes of the federal Constitution?
Because I'm betwixt and between the state law and the federal law, we don't take a position as to which is the specific, but the result of them, we believe, is the same.
I understand that you think all roads lead to Rome and we win. I appreciate that. I appreciate that, but for our purposes, if we're considering a remand, that's another issue that
Law,
I guess
are you still
you
here?
don't have a position on, so it would have to be explored.
Well, the Sixth Circuit has operated under the view after Hall that the interest that's being taken is the
Law,
equitable
can you
interest
just
in the property.
babysit for just a minute so I can take a
the
short
value-
break?
The
I'll be right
distressed
back.
value of the property less the unpaid taxes.
And that might be wrong, though, is what we're exploring here. It might be that the taking is the taking of the house in foreclosure.
Well, this
when fee simple passes from taxpayer to sovereign.
So, no, Your Honor, we disagree with that because the payment of the tax itself is not a taking. So if the value of the property at the time...
I understand that, but you're resisting, or I thought you weren't taking a position. I guess I'm wondering which it is. But isn't there at least a colorable argument that a taking occurs when you take title to my house?
Yes, Your Honor, there's a colorable argument.
All right, thank you. Then we don't need to go further, I don't think.
But can I just ask you that, to follow up on that, isn't the relevance of determining whether a taking has occurred just to get us to the point of determining what is owed to the taxpayer? In other words, it's not like a free-floating question of, you don't dispute that a taking happened here in the sense that, right?
No, after Tyler, it would be foolish for me to
Okay, so you don't dispute that there's a taking. So to me, it's not so much when that taking occurred, except insofar as we think that when it occurred relates to when it should have been valued or what its value is. So the bottom line of all of it is what is actually the value of the taking that occurred. And so, I mean, I suppose you could say we reach all the way back to the point at which, they first noticed him that he had his house foreclosed, or when the title passed, or all of those pieces. But there's also the argument, which is what the Sixth Circuit determined, that it is at the point in which the government sells the property, recovers its tax amount, and gives the person back the excess. Not so much the taking, but that's the value of what has occurred as a result of the taking. That is the just compensation that is owed to the person in light of this taking that everybody agrees happened.
Yes, Your Honor, we agree.
Mr. Nelson, did you have a back half of your answer to Justice Gorsuch's question? He asked whether there was a taking when the foreclosure occurred, and you said there is a colorable argument. Is there a but to that?
There's a colorable argument that, so the question was I believe there's a colorable argument that there's a taking when title passes. The but I would add is, the question is, title passes, what portion of the bundle of sticks is actually being taken? Because if the property is worth, for example, the same as or less than the tax that's owed, and the property is foreclosed upon, the property is received in payment of the tax, and there is no taking at all. So the interest that's being taken, if at the time of the right of redemption expires, would be the equitable interest. And I don't believe that there's actually a difference between the respondents and the petitioner on that point. It's not the entire home.
And when you said the taking, whatever it is, occurs at when the title passes, which is, I think, the same thing that Mr. Liu said, that might be different than when the foreclosure occurs. Is that correct?
The title will not fully pass until the right of redemption expires. So the right of redemption here expired 21 days after the foreclosure judgment was reinstated. Typically, that occurs under Michigan law.
I feel like he's already given his fucking answer. Can we move on from this shit?
Of each tax year. Thank you. With regard to some of the discussion with regard to the issues, there was a question with regard to safety valves that Mr. Liu indicated. For the court's purposes, I would point the court to sections, Michigan compiled laws, section 211.78H, 78K, and 78Q, for the purposes of identifying how Michigan law, like the law of most states, provides for ways for property owners to avoid foreclosure where they are unable to pay, or there are issues with regard to disability that would prevent them from paying. With regard to the question, there was a statement with regard to the federal government about what the IRS anticipates receiving from a forced sale. The IRS typically only forecloses on properties that they believe will sell. The states, when they are foreclosing on properties where there is no, where taxes are delinquent, there is no such selective process. They simply foreclose on all of those properties. Some of them are unbuildable lots. Some of them suffer from environmental contamination. Some of them are blighted, and they do not have an anticipation of sale. So typically, we would anticipate that the sale of, that auction sales of tax foreclosed properties would be at a lower rate than IRS foreclosures.
Thank you, counsel. Justice Thomas?
When you said earlier that your process is similar to historic process, what do you mean by that?
I mean that historically,
Not Thomas with the history and tradition.
The foreclosure process followed
Never
by
would
an
have seen that
auction
coming.
to recover unpaid and delinquent property taxes. Some of those, and there are a variety of intermediate processes that states have adopted that are in the historic record. We do believe that the Cooley Treatise sets forth a fairly wide range of what those practices are, but the overall foreclosure, auction sale, and return of the surplus proceeds process that this court identified in Tyler is consistent with what Michigan is now doing and the effect of what has happened in this case.
Oh, dear God. Can we get into rebuttal? I'm already done.
Justice Sotomayor?
You said
Mother-
that the foreclosure judgment
Shut up.
expired on March 31st, 2018. The auction took place a year and a quarter later, July 16th, 2019?
So the foreclosure judgment was reinstated on June 12, 2018. The right of redemption expired on July 3 of 2018. And because there was not an opportunity to notice, to get the property into the notice package with regard to the next auction, the county waited a year. Yes.
So how do I deal with the fiction that the auction price could be just compensation for a taking that occurred a year earlier? The market could have crashed, anything could have happened. How do I deal with that fiction?
So inevitably, there's going to be some lag between a foreclosure and an auction. And just as
No, not inevitably. the federal government, and I don't know what the historical practice was. I suspect it was that title passed when the auction or redemption was after. I mean, there are a lot of things
They probably
at the
didn't
founding. I
have
don't know
this
what they
many
are
fucking rules.
to avoid that.
There are ways to avoid it. If there is a specific concern with regard to events that occurred between the time of the taking and the auction, those would be a basis for challenging whether the auction reflects or establishes just compensation. Those challenges were not raised here. There was no challenge to the adequacy
Change
of
the
the
record.
surplus
This
proceeds
song
based on the time
sucks.
between when the foreclosure judgment was reinstated and the right of redemption expired and when the auction occurred here.
Okay, thank you, Counsel.
Justice King? Justice Gorsuch? Justice Barrett? No. Justice Jackson? Thank you, counsel.
Thank you.
There it is.
Rebuttal, Mr. Ellison?
We welcome our brother's concession here that there has been a taking in this case that is contrary to their position, of course, in the trial court below. We welcome that concession, and we think it narrows the scope of this case because now we're only talking about valuation at this point. I would point this court to Virginia Electric and Kirby Forest that says that when there is a process that is being undertaken for takings, the depreciation of the value caused by the taking itself, or in Kirby Forest, the prospective taking that's about to occur.
He did admit to the taking.
That obligation, that loss is borne by the government.
That's why I
not
tell
by
these
the former
motherfuckers,
property
don't be
owner. And I would
making
point this court
concessions
to
like
those
that.
cases. I would also have to disagree with my brother,
Doesn't matter
counsel,
who it is.
that there was a redemption right. Below there was an attempt to redeem and it was denied. I think that's somewhat a side issue on this part, but the reality is that the government was not going to give back this property despite all the efforts of the Pung family. And it's been a frustrating, I've been the trial attorney since the very beginning on this. It has been a frustrating, awful case to try to tell someone they're going to lose their family home, and there's nothing you can do to get the government to stop them from doing that. So I know that's kind of beyond the scope today slightly as to the issue of the taking valuation that we've narrowed this case down to, but the Pung family is here today, and they are devastated by the loss of this family home. And what they want is the justice that hopefully the just compensation clause should provide for us in these circumstances. I would finally just like to say is that the arguments of brother counsel was surplus proceeds is the end-all be-all, and I think at least I take from the questions today that can't possibly be the rule in these circumstances. But what he's not engaging on, and I believe Justice Gorsuch, you've referenced it with Mr. Liu, is you got to take the bitter with the sweet. If you're going to take the benefits of tax foreclosure and you're going to take more property than necessary, you've got to also take the historical practices of the limitations on there. And if you're going to act in furtherance or beyond those historical limitations, whether it's taking the Peloton bike or limiting yourself or all the limits that are traditionally there for normal debt collection practices, you also have to take all of those as well historically to benefit from that. And if you're not going to take those, you're no longer a debt collector. You're now a confiscatory government, and you're responsible under the Takings Clause. Thank you very much.
Thank you, counsel. The case is submitted.
Okay. All right. We can talk about this for a minute. Law, if you want to come up, because, God, you probably understood this more than I did. Here's what I'll say, and this is just opinion-based only. At the beginning, I did not think that this was going well for Pung. Sort of the first half of her, I would say the first quarter of this was a little rough, right? Like when we got into it, law came in later. Give me just 1 second. It was not going well, but then we sort of started seeing this like shift with the justices as I believe it was Roberts who weighed in first, and then I saw Gorsuch weigh in, and you sort of started seeing this shift. And then as they got into kind of sort of questioning down the line, it got into a lot of nuance and bullshit. But you literally saw, I guess it's the attorney for whoever's representing Isabella County and ostensibly Michigan here, say like it's a taking. So I thought that was a really banger rebuttal. I don't know, Law, you probably have a lot more thoughts on this than I do. The only thing I'll say, one more thing, is just if he didn't know the tax in the first place, I think giving him fair market value is what should happen here. I realize it wasn't what was being argued, but I think it's only reasonable. Please go ahead, Lo.
Yeah, I mean, I hadn't read this case or looked into it at all. So, everything I know is just coming from what we heard in oral arguments. So I may have missed stuff, but yeah, this one has a lot of moving parts. So I doubt that's, whatever is held for here is going to be a very broad, sweeping opinion. It'll probably be pretty narrowed, but I think at the end of the day, the justices, I think there's at least five that are like, seriously, you took somebody's house for a $2,000 debt, and I think that they're gonna work themselves into a situation that makes that not okay. I mean, first you have the general takings clause issue that, there's this $2,000 debt, and yes, the government does have the authority to seize property for tax debts, but when they sell it at an auction and it gets 1/3 of the value, then I think you're and the backup argument is the excessive
Oh,
fines.
somebody's knocking at my door. I'll be right back. Give me 2
No
seconds.
worries. So you have the argument about the excessive fines, which becomes an issue because the actions of the government have now decreased the market value of that property. And there's it's generally in the law, if you do something to decrease the property value, that you're responsible for that. If I sell my house and then I burn half of the house down, uh, and that is incumbent on me, not the person buying the home, to come up with that loss. So when the loss is that the government, through a tax sale, did not actually achieve the fair market value, it's not much different than just saying that, hey, I'm not going to put this on the market and try to get a fair price for it. I'm just going to take the first bozo who comes in and offers me $20. That, yeah, that's challenging. So I was kind of with them at first when they said, well, hey, an auction is a fair market value. Anybody can come and bid on it, and whoever the highest bid is, that's representative of a fair market value. But then when we look at what was actually achieved, it becomes a more of a facts intensive analysis where you're basically saying that had this person sold their house themselves, they would have received 3 times more. That starts to become something that's untenable. And over all of this, the fact that Cass pointed out that this debt was in dispute, that should have put a stay on anything like that. That whatever is in dispute should be reach a final resolution before something unredeemable comes back.
That was going to be my question. Like, how did it get to this point? If it was still being disputed, but also how did it get to this point? And like you said, to 5 of the justices leaning in that direction, how did it get to this point over a $2,200 debt? I get the government's going to get their money, but there's better ways to do that.
Well, I'm just curious why there just wasn't a lien put on the house. Then whenever he sells the house, the government gets their money back. It's
Yep.
I understand, like, if somebody owes $150,000, you're not going to lien that because you're going to take the house and sell it. But over $2,200, there has to be at least some threshold where we're not going to completely upend somebody's life over 1 to 0.5% of the value of the home.
I think, like, anytime, like, my estimation would be this, like, right, like, if I'm the person that's just like making these laws, this is like my hypothetical situation. Anytime a debt is worth less than, say, $25,000, I don't think a home should even be remotely involved, right? Like, I think at that point, maybe you're reaching some sort of justification there. But $2,200 is absolutely ridiculous. They could have taken a car. They could have taken so many other things and just auctioned it off, right? Like, that's what they chose. He lost his home, and then it was in dispute, right? So arguably, again, to Law's point, and like I'd say, it shouldn't have even been like at that point. But the fact that it was, and they sold it, I think personally, just in this particular instance, and I realize it's not what was being argued, that's not the case I'm making, but he should receive fair market value for the property lost because he didn't owe it in the first place. And I think that that's what they had attested to, that he didn't owe it at all. Like they had acknowledged that.
How did it even get to the Supreme Court at this point? Why didn't a lower court rule in their favor if it was a disputed tax in the first place?
I'd have to go read back and find out. I apologize. It's been a hot minute. I read this like over a month. I think I read it like a month and a half ago.
My best guess would be is there is the Supreme Court decision, what was it, HEB or whatever they were talking about with the Scalia opinion that said that, hey, an auction is representative of a fair market value. So it may have been that whatever lower courts were kind of bound by that precedent, saying that well, hey, it was auctioned and here's this case that says it's a fair market value.
Yeah, good grief.
I don't know. I feel really bad for the family though. Like, and I think it got here because it was just ridiculous enough that they're looking at that. Like, in my mind, they're looking at it and they're like, what the fuck? Like, that would be me look. And again, I make no allegation that I have any sort of like legal or reasonable education to do so. But had I been looking at something like that, I would have been like, are you kidding me? $2,200? Fuck yeah, we're taking this. Like, I would have had questions at that point.
Yeah, this is not my strongest area of law. My only C, it was a C plus in law school, was in property law. So I'm probably not the best person to. It is so complicated and weird and illogical. Like things in property law that you think would just be common sense, it's like exactly the opposite. So, but at the end of the day, I think Everett has a good point there that they called it a foreclosure before, and they did concede to a taking here. And it was kind of fun to see the other attorney, and I think that's good, quick thinking that, hey, we're happy to take this taking issue now because now we can talk about valuation, and that might be where the question gets narrowed to here was no, okay, so we do have a taking here that was conceded. Now, was the value just compensation? And when you're talking about that big of a decrease, the question is going to be, well, is the tax auction, which was the route that the government decided to go that would inherently guarantee a lower value, was that the fair compensation when there were alternative means open to the government? That might be the question at the end of the day.
Well, my favorite part was obviously the rebuttal. I thought he came out really strong in that. It hit very well. And he also leaned into Gorsuch's point, which is like, you're not just a standard debt collector at this point. No, you're a government and you're subject to the takings. Like, I really like how he hit that point. And again, I'm not saying it'll matter. I don't know what they'll do in the case, but I think to your point, Law, they certainly have at least 5 or more kind of being like, this doesn't seem right. Could be wrong, been wrong before, but I don't know. The reason I picked out this case, because when I was reading through what they were doing when they set the docket, I was just gonna do start in with Hamani, but I was reading it and I was like, oh, this is seriously fucked up. Like, this is one of those weird ones where it is a lot of complexity with property law and stuff like that. And I get that. And I make no allegation that I have any legal knowledge towards it. I was just like, this just seems wrong. Like, this doesn't sit right with my soul. So I figured it would be interesting to at least listen to.
Thank you for doing so.
Oh, you're very welcome. We're going to be back next week with US v. Hamani and Hunter v. United States. Both of those are good. US v. Hamani is the Second Amendment case dealing with substance abuse and whether you can be armed, which I love. And then Hunter v. United States is On waiving your right to appeal, does like a judge's statement alter that? It's kind of a weird one, but I thought it might be interesting to listen to as well. Law, you're absolutely welcome on either of those, but United States versus Amani in particular, because I know that's your sort of specialty.
I just wish it wasn't this case.
I thought that there were much better cases that they could have taken. I wanted
Well,
them to do Duncan v. Bonata. Like, that was the one I was really, really hoping for.
yeah, Bonta, yeah.
Or Bonta, sorry.
Yeah, the the Hamani case. There were other less bad facts, substance cases that were there that they just denied review on. So there looks like they're set to rested on Hamani. And for those who don't know,
go ahead, please.
yeah, Hamani had to deal with um, the whether you are a casual user of leafy substances, does that mean that you're inherently denied your right to bear arms even when you're not using said substances? And the facts of this case are not very good, just because the person was not only a user of leafy green substances but had other substances with him. Um, there's clearly, I would have much preferred a case that, hey, there's a grandma with glaucoma that that uses it once a week to to get some comfort, versus a guy with multiple criminal and trafficking convictions saying I still have a right to bear arms.
Well, I'll tell you, when I kind of briefly read through it, and I want to read like the entire cert petition, but I just haven't yet because I'm lazy. Let's be so real about where I'm at. When I read through it and kind of briefly went over it, to me, it seems like it's just going to be another Rahimi where they're going to use it to narrow Bruin. And then you're going to have the Thomas dissent where he's like, nah, I fucking meant what I said. That's just my speculation. That's how I feel about it. But I was like, nah, this is not great, but is what it is.
We shall see. Yeah, if my schedule allows, I'll definitely be there for it.
Sounds
so,
good.
real quick though, the 30% tax on everyone. Just get done with this.
Oh.
I mean, Law, how much of our tax, or how much of our court system is bogged down by ridiculous tax evasion and tax, like people that just don't know what the federal government is requiring them to pay. Like, I mean, we play a guessing game with that every year, and like how much would our system be freed up if we didn't have to deal with not knowing?
Yeah, that's a good question. I don't do much in the civil world, so but whenever you look up a court docket, it is overwhelmed with city and county versus, or state versus this person in tax courts. So generally they kind of keep. I think the fact that we have entire courts that are dedicated to doing nothing but taxes kind of answers that question in and of itself. That it is a ridiculously complicated web, and I hate that the government knows exactly how much they owe, how much they want me to pay, and if the number I calculate is different, then I'm under the lens and face potential civil and criminal charges.
That bothers me so much.
I just want you to know, guys, that if you ever elect me to Congress, the first bill I will push will quite literally, well, maybe not the first one, sorry, the second one I will push will be, just send me a bill, government, tell me what I owe you, and then we're goodsies. Like, I think that's so easy.
Cast for Congress.
Most other countries do that, right? Like, I at least when I speak to people from other countries, I can't I've never lived in them and paid taxes, so I can't allege it from my own experience. But I only lived in Australia, but I didn't pay taxes there. But like,
yeah,
it's fairly simple. They
Yep.
just take it and like you're good and you know what they take. Like it's not a mystery. They tell you they take it. But like I'm fine if you just want to take like that certain percentage out of my paycheck and I never have to fucking worry
Yep.
about it again. I'm
Exactly.
good with it. Like some people may not be. I'm cool as long as the government updates me if that number changes. Like, say my tax rate goes from 28 to 32. Well, I want to know why. I want to see that bill. Like those are things that are reasonable to me. But since we have a pretty open flow of information in this, well, should have a pretty open flow of information in this country and access to bills and certain things that they pass, I don't see why it would be that difficult. But I'm here for it. I think we live in a day and age where we don't need to do all this. And we have so many like IRS workers that just sit there to basically either tell you, you didn't pay this right, we're going to fine you, or refund people's money that they already knew that they were supposed to get back. Like, I don't want to pay those motherfuckers anymore. Go away. Sorry. Had to go on a little bit of a rant.
Yep.
My bad, guys. Anyway, so yeah, I'm really kind of hoping Pung at least gets fair market value for his house. Like, at least him, because I think this case is just so fucked up that he should. But if he doesn't, I hope to Justice Jackson's point, he can pursue this through, something else and get that money. I think what happened to him was just atrocious, and government shouldn't be able to get away with this shit. Any more thoughts, either of y'all?
Nope.
I'm here. Thank you, Cass.
All right, guys, I'm going to go ahead and end it, get something to eat. Thank y'all so much for coming up. Love you all. Love you, Ken. And thank you to everybody in my chat. And I will talk to you guys soon. Bye.
Have a good one.
You too.